Live.
All right, welcome back to the House Judiciary Committee this Wednesday morning, April 30th. We're going to move around the schedule a little bit because there's a time issue with Pietro Lynn. So, Pietro, if you could identify yourself for the record and please weigh in on H511, and hopefully you've heard some of the testimony and questions that have been kicking around. So, over to you. Thank you for your availability.
Yeah, thank you very much for having me. My name is Pietro Lynn. I am an attorney. I practice at the firm of Lynn, Blackman, and Toohey. We represent almost all of the school districts in Vermont, and I think I can answer a lot of the questions that were raised earlier. Let me start by just giving some background around the interaction between school districts in Vermont and law enforcement. We have for 20 plus years been doing this work with districts, and the advice we give to districts and the practice followed by districts is uniform. And that is that when law enforcement seeks to enter a school building, we require a warrant, a judicial warrant, in order to let them in, that unless there's something going on in the school that requires us to call for law enforcement, that schools are a safe place. It is an environment for learning where we are supportive of kids. There may be circumstances where, with parental consent, law enforcement is entitled to ask questions of our students. But again, we do not allow law enforcement to enter schools as an opportunity for them to engage in investigation, or in this instance, to take into custody persons who are undocumented. That is just not something that we do. And so in some ways, if the question is, do we need this law to create a circumstance where federal law enforcement officials are not allowed in without a warrant, the answer is almost certainly not. And the concern that I have here is that having this kind of language and potentially a policy that requires school officials to discern the difference between a judicial warrant and a warrant that is issued administratively, even with immunity from state law prosecution, may create circumstances where federal prosecution is initiated against school officials who make a mistake. And the reason we know that's true is we are already seeing instances of state officials, judges in Wisconsin, who are being charged federally for violating federal law, where arguably there is no violation of any state law that occurred. What do we, I guess another question is, what kind of information do we provide federal law enforcement or any law enforcement? And the short answer is we are not a clearinghouse for the police. We are controlled by FERPA, the federal privacy laws having to do with students. So we don't provide any information about whether students are documented or undocumented. We don't tell people where their country of origin is. Law enforcement is not entitled to any of that information without either an authorization from a parent, a subpoena, a valid subpoena, where we have an opportunity to first notify the family that the subpoena has been issued, or again, a judicial warrant. And so I guess what I would emphasize for all of you is that Vermont schools do not act as a clearinghouse for the police. We are not an instrumentality of law enforcement, whether it is state or federal. The concern, again, is that where we have language that grants immunity, school officials could easily be confused into believing that this alleviates any concerns about criminal exposure. It does not. Almost surely, if we are in a tussle with federal law enforcement officials about whether they're entitled to come into a school, the charges will be brought under federal, not state law. And the statute does nothing to insulate school officials from federal criminal exposure. I think it is important also to understand is that we talk in the statute about exigent circumstances, and I heard my colleague talk a little bit earlier about exigent circumstances being those where the school calls for assistance. Well, exigent circumstances may also exist where federal officials have observed or learned of something where they believe there are exigencies that support them entering a school without a judicial warrant. I can imagine circumstances where this statute or this bill, along with any policy that is promulgated because of it, will create confusion for school officials at the building level and lead them to make a mistake. And that mistake could indeed lead to federal criminal charges against them. So I look at this bill, and I think what I can say is that our practice is to follow what is contemplated here, but not just when it comes to immigration authorities, to all law enforcement authorities. And I would also urge all of you to understand that we do not in any circumstance want to be in a position where we are allowing ICE officers to enter our schools. Thankfully, nothing like that has happened in Vermont so far. I am not aware of a single instance where an ICE officer has sought entry into one of our schools. That is not something that has happened here. I'm not telling you it can't, but I would expect that if it were going to, we would have heard about it now. I heard a little bit earlier about some concerns about whether there are any federal laws that may apply here. One of the laws that we're aware of is the Immigration and Nationalities Act. And the language of the act requires that local officials, including state officials, not restrict or prohibit in any way governmental entities or officials from obtaining information from schools. And I think it's important to understand that the federal law or the federal authorities may have a very different view of what our responsibilities are under federal law than perhaps we do under state law. And so I'm just asking all of you to think very carefully about the kinds of requirements we put on our school officials, where in fact we may put them in a position where their exercise of judgment in the moment creates for them the possibility of going to prison.
So before I go to you two, I'm going to take the first question and then Angela and Zach after. So do the policies that are out there right now provide sufficient information for staff to understand the difference between a judicial warrant and an administrative warrant? I don't know if you were here earlier. We'll probably have some of these examples on posted. And if it's not clear enough, should we at least have a policy that kind of outlines that better than what we have now?
Yeah. So let me respond to it this way. I worked with the school board in Winooski around their policy. A careful reading of their policy will demonstrate to anybody that their policy is no different for federal law enforcement than it is for any other law enforcement. The practice remains the same. It's exactly what I said to you, which is we don't let people in without a judicial warrant. And so, going back now to your question, the question is a good one. What do we do to recognize the difference between one kind of warrant and the other? The way it works in practical terms is if they have a judicial warrant, they're not going to wait. They're going to show you the warrant and then they're going to enter. And if you don't let them enter, they will enter forcibly. So it's not as though, we have hours upon hours to make these judgments. And it's not like they really care all that much whether we recognize the difference between one warrant or another. Do school officials have specific training on recognizing the difference? No. And I would suggest to all of you that the practice now in place is that if a principal is aware that a federal official is there with some kind of warrant, we don't know what kind, they're going to do one of two things. They're either going to call their lawyer, someone like me, or they're going to call their superintendent, or both. And that person is going to have to make decisions. But in some ways, the decision is an easy one, because if the federal officials are willing to wait, it's because they don't have a judicial warrant. If they have a judicial warrant, they will not wait, nor do they have to. So
you don't think it's necessary to have some further clarification, even in policy related to the differences in warrants?
Well, I guess what I would say is this. So I recently did a training at the Visbit Spring Conference. The training was exactly on this issue. What are our responsibilities to federal and state law officials? What if ICE comes with a judicial versus administrative warrant? And this is the kind of training we are focusing now on in terms of school officials, so that in the event this issue arises, and it is not yet, but it may in the future, they can recognize the difference and hopefully act accordingly. But again, the one thing that we are clear on is that we do not give consent for law officials to enter our buildings. And the question was raised earlier, what is private, what is not? We live in an age now, because of school shootings, where we don't let people in the building unless they have an appointment or unless they articulate to us the reasons why they want to come in. We have cameras, we have audio means of communication, and the doors remain locked unless or until somebody identifies themselves sufficient that we let them into the building. Now, there are some exceptions, and those relate to the times when kids are coming and going and the like. But mostly, security in schools is fairly stiff. We don't let just anyone in. So if a federal law enforcement official comes to one of our schools, what we can expect is that they will identify themselves at the front door before they enter the building. And that is the moment where they will have to demonstrate that they have either our consent, they won't, or that they have a judicial warrant to come in. My advice, however, is if they insist on coming in and they only have an administrative warrant, guess what? I don't think it is, we want our school officials trying to stop federal officials who insist on entering the school despite the fact that they don't have consent from doing so. Because again, that will only create the opportunity for physical confrontations. Our school officials are hardworking, good people. I don't think tussling with the feds is a good idea, or in the alternative, an opportunity for them to be charged criminally.
Okay, all right, thank you. Angela and then Zach.
So thanks for being here, Pietro. I'm looking at the Winooski School District policy, which is far more detailed than this bill. And it does say, just as you're describing, that should an immigration agent request access to a school site, the superintendent or authorized designee will ask for credentials, immigration agents must provide written authority from ICE, etc., and a warrant signed by a federal or state judge, which specifies the name of the person under arrest must be provided for entry. So in this policy that you vetted, it's very clearly spelled out. Is it just the existence of the presence of the reference to immunity that concerns you about the language of the bill? Because otherwise, I think they're quite similar.
Yeah, so I mean, I guess I would share with you, Angela, that my concern is twofold. One is that the immunity language is in some ways superfluous. We're not worried about state law criminal charges for school officials who hold up federal immigration enforcement officials, right? That's not going to happen. We're worried about federal law, and this does nothing to deal with federal criminal law. And so in some ways, it may be confusing and misleading for school officials. They may think that they have a wide degree of latitude to try and enforce this policy, whatever it is that's promulgated because of the bill. They don't. Even in Winooski, I think if we had a conversation with the superintendent, what he would tell you is that he's been very clear with his building officials that if people are going to come in, if the feds say they're going to come in, we let them come in because we don't want to engage in a fight and we don't want to have criminal charges. That in the best of all possible worlds, we are going to have time to review the warrant to make sure it's the right kind before we let them in. And so if you're asking me, what do I think that makes sense? I think it makes sense for the statewide educational organizations like the SBA, VSA, VPA, and VSBIT to continue to train school officials so they understand the distinction. But what I worry about is that we will be in a position where, out of a sense of overzealousness and protectiveness around their students or staff, that we will have administrators who make decisions in good faith that put them in criminal jeopardy. And I worry about that for our principals and assistant principals in Vermont, who are already overloaded and working incredibly hard to serve our communities.
Gotcha. So that I guess the number 9 and the when you see policy requirements does say, should agents refuse to wait for superintendent authorization, WSD staff will not obstruct, block, or delay the agent's entry, but will inform the administration immediately so that an emergency hold protocol is put in place for all learning areas and all families are notified of the entry.
That's exactly it, right? Like we understood that on the one hand, we want to make sure that we respond to these circumstances in a way that's lawful, that's consistent with how we have dealt with law enforcement for years and years in Vermont. But at the same time, we never want to be in a position where our administrators are forced to bar entry to the school at risk of their physical persons or at the risk of going to jail.
Okay, so then number 11 says neither the district nor its staff, faculty, employees, agents, or site-based officers will honor or comply with or otherwise reveal information in response to ICE detainers or ICE requests within district sites absent a duly executed judicial warrant. So is this, sounds like there's this attempt to be very clear about physical, there will be no attempt to physically block or obstruct an agent entry, but then there's leaving room for, non-compliance to reveal information.
So I guess what I would say in response to that is as I understood that part of the policy, what we're really trying to do is be clear that we don't provide law enforcement with FERPA protected information under any circumstance except for the ones contemplated by the law. And that those circumstances are where there is a warrant or a subpoena. And of course, there's a very orderly process that is contemplated where a subpoena is issued. Namely, what we do is we notify families of the subpoena. They're given an opportunity to present information to a judge to quash the subpoena. And then, and only after the judge has had that opportunity, does the court order production of information that is being sought by law enforcement. But I will say this, it is important to understand that schools in Vermont do not collect information that will be helpful to ICE or any other immigration authorities. We have no need to know any of that information. All we have to know is where the parents live for purposes of residency. That's it. And so we have made a conscious effort not to collect information that could ever be used against our students in an immigration process.
Thank you.
Okay.
Thank you, Chair, and thank you, Pietro. Really appreciate the testimony and thank you for your time. I know that there are obviously heavy demands on your schedule. Couple questions. I think one is piggybacking on the immunity concept. I'm sorry, we're getting some background noise here. I'm wondering if there are any other actions that teachers or administrators take that are protected by any kind of immunity under state law.
Well, so there's there are civil law immunities that exist. And so by virtue of being public officials, if they get sued, they may be entitled to qualified immunity, but that doesn't really do much in the criminal sphere. Where criminal charges are being brought against teachers or administrators for violation of federal or state law, good faith generally is not considered a defense.
Thank you. And the second, and you may have heard this in one of my previous questions, is the concern that students aren't mentioned anywhere in Section 1 of this legislation. And I'm just curious, like whether you think that students should be included in this bill, beyond Section 2, and really all it is just mention of privacy of students. But I'm curious if we are to entertain this bill, which we obviously are doing by taking this testimony, what additional scope or language should be added so that this is actually trying to accomplish the intent of what it's looking to do?
Yeah, I guess, so let me start by saying this. I think your intent is to make sure that school officials understand that we don't just swing the doors wide open for law enforcement, whether it's federal or state. And in particular here, it's federal. And I would say that's already what we do. But more importantly, we are also governed by federal law when it comes to student information. So we're never going to provide that, and that applies to students. I would also and I know it's a little stream of consciousness here, but I would also say to you that we are deeply concerned about our staff. It's not just students, and if we have staff who are undocumented, I think if you polled my clients and the school administrators and teachers in the state, you would find that they're deeply concerned that their valued co-employees not be dragged away by ICE either. And so, I understand the impetus to include students specifically, but I think that the concern extends to staff also.
And so I think to put a finer point on it, not only is this legislation unnecessary, but it could potentially put your teachers and school administrators in danger.
So this is really I guess the reason why I'm glad I'm here today, because I think that my clients share the concerns that are driving the legislation, right? Like we understand and support the sentiment, but the problem is that we understand that in trying to implement it, no matter what your policy says, that no matter what this bill states, in the end, it's creating the kind of potential exposure criminally that is very serious. And I think with the current federal administration, the risk has only increased that somebody inadvertently could find themselves on the wrong side of federal charges. And I doubt that's something any of us want to see.
Thank you very much.
Ian and then Angela.
Hey, Pietro, really appreciate the testimony. I think my question to you is, so it sounds like the practice is what we're trying to accomplish currently is happening. The practice is what we want here based on the bill language. What I want to know is what would prevent a school from just changing their practice tomorrow and doing like having an open door policy. Is it somehow enforced, or are they basically looking to you or their attorney and you're advising them and they're following your advice, but what would prevent them from just not following your advice in the future?
Well, that's the lawyer's dilemma, right? Like the client can get the advice, they never have to follow it. But the reality is this, like we are fortunate in Vermont. We have dedicated professionals who work as school administrators. They all share values about caring about students, protecting students, creating a learning environment that is conducive to students feeling safe. Like this practice, the way we approach this is, as far as I know, uniform. And your question is a great one. Like, could it change tomorrow? At some level, the answer is I suppose that it could, but I honestly, I don't see any likelihood that it will.
And just and so I think that's kind of what I'm thinking about with this is just if we were to move forward with some sort of language that's proposed in this bill, it would be basically saying keep the practice that you have, and we're saying that it has to continue. The criminal exposure that you're talking about that this bill creates, it sounds like the exposure is already there, right? Like I understand that maybe depending on how this is written, we could be creating more, or we could be creating more confusion, but there's already policy in place and practice in place in Vermont where you're going to have interactions between federal or local law enforcement officers and school employees. And that's, there's always going to be exposure and risk. So
hold on a second. I hear you. But let me respond this way. Two things. One is I worry that by virtue of this statute that it will invite scrutiny by the federal law enforcement officials of our schools. What we know about the Trump administration is that They view this as antithetical to the work that they are trying to do. And we've seen in places like Maine and other locations that this is in some ways a target that's being placed on the back of our schools. And I would not want to invite the Trump administration to make an example of one of my clients. That would sadden me. The other issue is that look, like if you want to make a rule like this about all law enforcement, including state law enforcement, I would say to you that something that says that school officials don't let law enforcement into the building absent an invitation by law enforcement or exigent circumstances or with a warrant, that is something that reflects the current practice. I just worry that if we are singling out ICE or some other organization, given the sentiment of the moment, the amount of energy that is focused on this issue, and the amount of emotion experienced by my clients around this issue in particular, that we will invite a disaster for school administrators.
Okay, that's really helpful. Thank you.
Angel.
I think that answered my question.
So this may be more of a question for Emily Simmons or Sue Siglowski, but I'll ask you as well. Just and it's back to the whether. So we have at least one school that has sounds like a pretty extensive policy that would really help individuals in that school to address this situation we're talking about here, but all law enforcement as well. If we want to have a model policy, not necessarily tell school districts that they have to adopt it. I know that we do that sometimes. We say there's a model policy and they have to adopt it, but at least a model policy that's done that work so that if the district does want to proceed with a more extensive policy than what CVU has, for instance, that it's available. And would that be helpful?
Yeah, I mean, look, one of the great services that VSBA provides to its members is to develop model policies. And I would, I'm sure when you talk to Sue Siglowski, she would say to you, we would be glad to do something like that and have it extend to interactions between schools and law enforcement. And I think that would be something that actually would be very helpful to schools. But let me say this, as a former school board member, you know this, but I'm going to say it anyway. We have to be mindful of the differences between policy and procedure. And in the school world that I live in, there is a difference and it's meaningful. The school board is responsibility for the overall policy. What is our philosophical approach to these issues, and how we deal with it is procedure. And that's generally laid in the lap of the superintendent of schools. And so, right now, most of these issues are in the form of procedure, meaning the superintendent makes those determinations and communicates them to the building administrators. Winooski, if you read the Winooski policy, it's a sanctuary schools policy. Now, I'm not sure that anyone has actually provided sanctuary under the policy to an extent greater than already exists, but that was the energy, I think, behind creating that policy, because in many ways it simply reflects the current procedure used throughout Vermont.
So I will ask my question actually, since and now I have two questions. So if we were to remove the immunity reference here, the provision regarding immunity, could you see this bill or some version of it, and I won't ask you to comment on a future version, but as a way to ensure that all schools and therefore all children and school employees in Vermont are uniformly protected to the extent possible, understanding that implementation of policies varies in a little bit from school to school and all of that. But could you see this as a way of ensuring that equal protection? And I'll use the term protection broadly, because I really appreciate the language in the Winooski policy, which states that the school district
shall establish itself as a safe place for its students and their families to seek help, assistance, and information if faced with fear and anxiety about immigration enforcement efforts. And I think that's really important. And you know, I understand and respect your concern about creating a target, you know, putting a target on the backs of schools or the state. But I'm also mindful and wanting to balance that with the very legitimate fears of the people, not entities, not a school, not a state, but the people in our schools who already have a target on their backs.
Yeah,
And providing an equal measure, an equal level of protection for all students and school employees in Vermont.
Yeah, so let me respond to that. You have, you know, quite rightly, you have identified the part of the Winooski policy that is different than the general approach to law enforcement in Vermont. And that is to provide information and support to families and students who may be undocumented or may have fear because of their immigration status. That is something that has nothing to do with allowing ICE or federal law enforcement in or not allowing them in. That's a different thing. And that is, and you know, I think that was an area where Winooski rightly understood that they could do more than what they were already doing. And so I guess what I'm saying to you is, yes, that is something that is separate and apart from how we deal with federal law enforcement when they show up at our door and insist on coming in.
I hear that, but I think that they are related, not unrelated, because there is the information about how we'll deal with ICE when they come to our door. That is the sharing of information and being able to state very clearly to someone who's concerned, how that will be. I think they're related. I understand that it's also a bigger question. And all kinds of information can and should be provided. But I think being able to state very clearly, definitively, and especially being able to point to a state law that says this is how we'll handle it, I think is very powerful.
So I guess what I would say to you is that I would encourage the committee and you, if you're going to do that, then to broaden it to all law enforcement. Because in the end, I mean, whether it's federal or state law enforcement, having police run around our schools, disrupting education, frightening children, making staff anxious, I don't think that's something we want. And so I don't mind. I think it is smart to have a policy that addresses law enforcement interactions with schools generally. I like for VSBA to be the entity that does that work because I have great confidence in their work. It doesn't mean I don't have confidence in others, but I've seen
the help them write the policies, right? So
well, I do, yes. Sorry, that didn't sound good, did it?
No, I get it. It's totally fair.
But yeah, look, I think that it might be high time to develop that kind of policy statement around what is the proper role of police in schools.
Thank you.
Any other questions for Pietro? Thank you very much, and we give you 5 minutes for break before your 11 o'clock that you have. So
thank
you're
you
welcome.
very much. Great to see you all.
Thank you. Thank you very much for being available. Appreciate your testimony. Falco, if you could join us. Thank you for being here, Falco, and you could weigh in on this H511.
Good morning. For the record, my name is Falco Schilling. I'm the Advocacy Director for the ACLU of Vermont. I appreciate the opportunity to testify on this bill today and to be able to present to the committee. And luckily, I feel like a lot of the ground has been covered, and I think there's been a number of helpful issues surfaced. I want to provide just a little bit of context about why we support this legislation, in the drive behind this legislation, but also to respond to some of the specifics about the language that folks have raised and to echo some concerns other folks have had in places for potential improvements. So at a high level, the calls for guidance from schools when it relates to interactions with law enforcement has been something that has dramatically increased from our perspective over the last couple of months. Folks are reviewing these policies. They want to have more information. They want to have more guidance about what their roles and responsibilities are in those contexts, especially as it comes to designating public and private spaces. What are their requirements when interacting with law enforcement? So one thing I did provide to the committee was the ACLU Nationals guidance on immigration enforcement, which covers student rights, as well as our proposals for what any model policy should include. And I think that speaks to some of the concerns that were raised here today. Just generally, part of the reason that we support moving forward with this process of developing a model policy through the Agency of Education in collaboration with others is that it would provide that level of uniformity across the state. We have certain school districts. I've heard from a number of different educators in a number of different districts who have questions about this. What do we do? How does this work? Where can we get information? We've worked closely with a number of educators and other folks and attorneys to try and provide some guidance and model policy of our own that folks have used and has informed things like the Winooski policy that they have also worked on with their attorneys, as you've heard. And I think there's a lot of agreement in terms of kind of the four walls of what those policies might look like. I didn't hear anything today that would put us at odds with some of the advice that you're hearing from others. So, the core components of a policy when it relates to entry into school for law enforcement, the things that we generally recommend is making sure that you have a very clear distinction between public and private spaces. How do you do that? Appropriate signage and protocols. I think it's helpful for schools to be able to get some guidance on that when making those decisions and what they can do to help notify folks. One of the easiest things is signage. I've been seeing this in many places, including my 3-year-old and 9-month-old's daycare. They put up signs on the doors letting people know this is a public area, this is a private area. And that is helpful because they have an obligation in terms of protecting student safety and then also just helping to encourage parents in feeling more comfortable sending their students to these schools and understanding how the school will respond. And I think that's another benefit of a statewide policy is it provides uniformity for educators and administrators across the state. But I think it also provides some reassurance to Vermonters generally who are very concerned about this and what are the rules. And I think it's a place where we're not seeing a whole lot of difference in terms of what schools can do and what are those limits. But I think the more that we can communicate that is a very positive thing. The second piece related to this type of policy that we recommend is an internal protocol and the procedure to interact with immigration enforcement or other law enforcement officers. You saw some of that in the Winooski policy. We think that that's not spelled out in the statute, but I would imagine that would likely be part of the conversation with AOE and other stakeholders to flesh some of that, because you want to have folks who are designated and trained to deal with this. And beyond that, having a designated and well-trained individual who would be your point person if an interaction with law enforcement occurs. And I think that kind of takes me to some of the higher level bill language. And in terms of, point one, I have in terms of the access to immigration officials, I've heard, around this table, a number of other folks raise the proposal, why are we just limiting this to immigration officials? I think that's a great point. I think it's very smart to have a uniform policy for all law enforcement officers where we are requiring judicial warrants to enter into these private spaces to protect folks' Fourth Amendment rights. So that's something that I think we've heard from a number of different witnesses, and I think could be a positive change, but also makes this more comprehensive and provides more guidance to folks who are trying to administer these laws on the ground. Point two, I agree with folks who've raised concerns about the immunity provision. One, as you've heard, Vermont as a state can only provide immunity to prosecution under Vermont law. I don't know exactly what Vermont law might be implicated in terms of the immunity here, other than potentially physically impeding an officer, which is something we never, ever suggest anyone do. And I think that's helpful within the Winooski policy. So I have concerns about what message that might send to school officials, that they think they have a higher level of immunity than they might actually have. Because I think that should be informed, through their practices and protocols As we saw it laid out in the Winooski model, I think that's very helpful. You let people know that this is a private area, but you're not going to be physically impeding someone from entering that space.
You could construe simply not buzzing somebody through a door can be
Well, I think
pretty easy.
that is something they could do, but if it's in line with their policies to not let someone in without a judicial warrant, that is in line with their guidance and state law. And I think, that's something that should be considered. But if someone is using force to enter those premises, that's not something that we would ever suggest someone interfere with.
I was just countering what you said. We almost never do that and don't see it happening, but I'd be very easily done. Could cause jeopardy.
I mean, in a similar situation in a private home, someone has a right to not allow someone on their premises without a warrant. And this is a similar situation because this authority in terms of protecting private spaces is derived from the Fourth Amendment. And that's really what we're talking about is, Fourth Amendment protections extending to these private spaces. So I think there's concerns about the immunity language in there that you've heard from other folks, and I'm not going to spend too much more time talking about that. There's also, I guess I will spend a little bit more time. This has come up in the context of shield laws when we talked about this previously, where there's an attempt to, let folks know that they have certain immunities from state prosecution, but that does not necessarily mean that they might be immune from federal or prosecution from other states based on their actions. And we want folks to be informed about what those liabilities might be. And so hopefully any part of a model policy would be some training, especially for those point people with these interactions, to know how to deal with those situations and what their legal obligations are. Third, just looking at section 2, the model policy for regulating access to schools. It says the agency of education coordination with the Office of Attorney General to develop the policy. I think it'd be smart to expand that to other stakeholders. I imagine other stakeholders would be part of the process, but I think you've heard from a number of folks today who have valuable insight to offer into that process. We'd be interested in helping support that work. And then there's a number of others who have been involved. So I'm not asking to create a study committee or anything like that, but just saying that other stakeholders might want to be involved, including law enforcement, because there's a number of perspectives to take into consideration here.
Being in law enforcement, yes, I understand what you're trying to say, but I also want to ask, is there a longstanding history of Vermont law enforcement impeding the schools and in the learning environment?
No.
I can't say of any.
I can't speak to past instances, but I think as we've heard from folks, this is about trying to be prospective and protective of students' rights.
And it could also jeopardize things like SRO programs. There would have to be other things added to it for that, to allow for that to happen, because law enforcement's going to be inside the school, working with the school.
So I would imagine if we're doing a model policy that something like SROs would definitely need to be.
And law enforcement, I know state law enforcement, I don't know if you're aware, but I mean, most of us have policies about dealing with schools for this very purpose. Because we don't want to have this happen, and I think now that, well, we're gonna be regulated by a statute that we don't need, it really just shows a lack of trust for law enforcement. I think that's where it's perpetually around here, that's why we can't hire anybody,
Okay,
just a thought.
I don't think there's a question there, but
No.
if you want to proceed.
You call me on it.
So yeah, basic point is I think other stakeholders should be involved in that process. There are things to brought into that. I think we'll save our thoughts on SROs and armed law enforcement officers in schools for another day and another bill. But I think the reality is that they do exist. They are in Vermont schools now. And yes, that would be something to be taken into account in developing these policies. And then I guess the final point I'd like to raise is the date when this policy would be due. The policy will be completed by December 1st and be adopted by December 31st. Looking just at the school calendar, I think it would be ideal to have something in place for next year. Schools are wrapping up, outside of summer learning programs, but I think this would be something that would be very helpful for school districts to have in hand as they're going into the new school year, and that for them to be able to communicate to the populations they're serving as they're starting out the school year, as they're relaying other information, provide some of those assurances. And it seems like largely these are assurances of the practices that already exist and their application to new contexts and concerns that are being raised. So that would be a suggestion, is to move that forward so these can be available at the start of the next school year.
Right, yeah. Tom?
I looking at this, really the giant concern is federal law enforcement, from what I'm seeing here, immigration in particular. There is nothing regulating immigration from working with any other federal law enforcement agency. Correct. I mean, the FBI, ATF, they could all work together mutually, calling each other for help, whatever. They all operate under the same Department of Justice umbrella, right? So we could be taking care of that. And on the state side, we have fair and impartial policing. We also have this, we're not allowed to enter into a 287G compact with the federal government without the governor's approval. So we have an installation there about what we can do, having to deal with immigration. We have the Fair and Impartial Policing Act, having to deal with that other immigration issue. And I think we've had a really good relationship with the schools. And I'm just wondering why we think we need to have legislation now protecting our schools, or insulating our schools or putting up barriers when we already have a good working relationship with them. I just.
So I think when it comes to that, there's a lot of fear out there. And I think we can all recognize this. I imagine you all have heard it from folks in your communities. There's a lot of concern about especially how immigration enforcement is being handled in this country right now. And if we can move forward with a state uniform policy that's largely in line with how things are happening now, and that could provide greater assurances to the public, especially students who might not be attending schools because of fears of the interactions with especially immigration enforcement, whether it's on their own, based on their own immigration status or the immigration status of a parent or a loved one. This is something we heard reports of, not long after November, was that folks were just not showing up to schools or not bringing their students to schools. And that's detrimental to our immigration. Fear of immigration enforcement meant that students were not showing up to school.
State law enforcement's doing that?
No, I said federal law enforcement.
Oh, okay.
Yeah,
And
fear.
you're saying then why are we limiting or putting up barriers with our own state law enforcement and our working relationships with the schools? I go to school programs all the time, all sorts of things where I am entered in the school and they let me in, without knowing who I might be or what I'm up to.
So I think from a constitutional rights perspective, we are very supportive of having policies that don't have law enforcement entering these school premises without a judicial warrant, which is what you just heard is the standard policy across the state, largely from these schools. And we think it makes sense to put that into uniform state policy and support the suggestion that you raised of that, applying that to all law enforcement.
I apply it mostly in what I said to federal government entities. And then I also mentioned state, but to me, it literally makes no sense to do that. I pull up to a school and get out of a cruiser and walk into the lunchroom and hang out with the kids. I'm warned.
Well, I heard suggestions around this table from others that this should be expanded to include all law enforcement. We would be supportive of that. We are also supportive of the language of the bill as introduced. We'd be supportive of expanding that to all federal law enforcement.
Yeah, and I think in a policy, the idea in the policy as well is that it can be flexible for local school districts, that if they have SROs or if they invite law enforcement in the situation you just mentioned, because I know that, I don't know if they still do the DARE program where law enforcement would come in to teach. I mean, there's going to be any number of exceptions that presumably can be worked out into a policy so that we're not losing those connections. But we're also not.
It's just another disaster, I think, but okay. I understand.
And that would be like the permission, right? That was Pietro's
Honestly,
point.
though,
Was
in
like,
Vermont, around here in Vermont, we know our communities, things like that. I don't ask for permission. I walk up to the door, the buzzer goes in. Everybody go to lunchroom, okay, have a nice day. Whatever. Now, there's playground, whatever. Let all the kindergartners come over and climb all over a police car.
Right, yeah, you don't want to lose that.
Well,
So anything else?
I mean, I think just the one final point I would make is when we look, I think others can maybe speak to this, but in terms of the enforceability of these policies, these are largely guidance. AOE could speak more to what are the implications of not following a statewide policy. In some other contexts, there are, things like loss of access to training materials, other things like that. I don't see an enforcement mechanism. These are largely uniform guidance to schools on how they should be interacting in the bill as drafted with federal immigration officials. As I said, others have suggested to expand that. We're here to support the bill as that section of the bill is introduced, but would be open to expanding in other situations. But I think a policy could be addressing some of those other situations. And that is what I have to say today.
I appreciate it. Ken?
Do you hear from anybody that's in support of more of a overview of the activities of the idea of better security measures? Or is everybody just living in fear that the schools are going to be, they're going to be overrun by ICE? Or, I mean, I've heard references to November and then February and all that stuff, or January and all that stuff. So just wondering, is there any positive stuff that you're hearing from that maybe this is a good idea or that's a good idea, that some good things are happening?
I'm a little confused by the question. So are you related to policies limiting access to schools in particular?
Has there been any good things that's come out since this new administration? Because I think this is really what this is all about, that there's any positive information that's coming your way on how things are being handled?
Well, I will say from the perspective of the American Civil Liberties Union, we are in active litigation
Say something wrong?
on a number of issues. I'm not going to speak to the administration as a whole. I think some of those suits can speak for themselves, but in terms of access and having policies in place for schools to limit access for security purposes in particular, that is something that we have heard a lot about in terms of concerns around school safety. And you look at the underlying statute here and why folks are trying to make sure they have uniform policies around access to campus. A lot of those concerns are school safety issues, largely not related to law enforcement, often related to other outside threats or active shooter situations, which have become, unfortunately, all too common. And I think this is another safety concern that folks have raised in the school context and makes sense in terms of trying to create an environment that promotes school safety on those campuses.
But if I may, Chair, we're always going to have concerns on school safety, and we're always going to be, unfortunately, we can be proactive, but we never know what they're going to be doing anywhere. It doesn't matter. Obviously, school is one of our top priorities, and I'm just trying to figure out, I don't want to overreact. I don't want to create more bad actors, if you understand what I'm saying. And that's one of my concerns of this. I don't want to make, I'd really like to, I think what Representative Oliver is saying is on his policing level, he has a very good handle on, and hopefully all of Vermont does. And I know we focus a lot on Winooski, and we also know that Winooski is wide range and certainly very diversified with the student population that's there. So I think we're doing a pretty good job, and I want to definitely stay proactive with it. And I'm not sure this bill is necessary, but I'm certainly open-minded. Thank you.
All right, Tom.
You don't think that this, well, we say we want to do this so that we can help people feel better about being in the school, feeling safe or whatever, by saying we have to have a warrant. But you don't think that makes people now fear the police too? It has two effects, I think.
I think it enforces people's constitutional rights.
Are you afraid of the police?
I have concerns about interactions with police at certain times. I think a lot of people have concerns about interactions with police at different times, but I think this largely is just affirming people's Fourth Amendment rights and the ability to enforce them. But I think this is largely putting in place, and I think to speak to it, the fear right now is much larger, much more from federal immigration enforcement than it is from local law enforcement.
Exactly.
So I think, as I see this developing, it's more like we're looking for guidance and looking for a way to have guidance as opposed to trying to legislate at this high, at this level, what's happening in each school. And I think also letting schools ultimately decide what they want to do, but they need guidance on these model policies. And I think the next couple witnesses can really help us kind of understand that a little bit better. But anything else for Falco? Anything else? I appreciate your testimony. Thank you very much for here.
Thank you.
So Emily, nice to see you. It's been a while. When are you going to actually visit your home state of Vermont again so you can be here in person?
Well, I was just there earlier this session, and who knows when I'll show up again. Just watch out for me.
All right, excellent. So if you could weigh in on what we've been talking about, I appreciate your being available.
Sure.
And,
Yeah,
and identify yourself for the record first, of course.
Better believe I wasn't going to miss that step. For the record, I'm Emily Simmons. I'm the Agency of Education's General Counsel. Thanks for inviting me in. It's nice to come to a committee that I don't spend as much time in and see you all. Yeah, I think so. It's really been nice to hear the conversation so far. I don't know that I have a ton of ground to cover with you that you haven't already touched on, but the need for guidance was just mentioned. I think that's a really nice segue to what I wanted to share with you. The agency saw a need for some good, clear information for school districts in January. And so we put out guidance right at the end of January on immigration topics generally. So I thought I'd just show that to you for your awareness. It actually send a request so I can share that to you. It's posted on your committee page today if you'd rather me not share my screen, if you'd rather just look at your own screens. So we think that there are several topics related to protecting all students that it's important for schools to keep in mind. So that starts with what you've heard already from Legislative Council about all students' right to public education, regardless of immigration status. A student in Vermont and in the United States generally need not show proof of any citizenship or immigration status to be admitted to the public schools. Likewise, all students have a right to be to a safe and welcoming learning environment and to be free from acts of harassment or discrimination. That's regardless of national origin. As we know, national origin is a protected class in Vermont. So we just provided a reminder of those legal obligations in our guidance as well. We issued some FERPA guidance, very much along the lines of what you've already heard and consistent with the ACLU's FAQ document that I saw that was posted in your materials today. I would 100% reiterate what my colleague Pietro told you, that schools are not in the business, have no need, and in fact do not collect information related to or that would reveal a student's immigration status. It's just not information they need to do business, and it's information that would create risks to their student safety, and so that just doesn't happen. We reiterated in this guidance that given that there are two exceptions to FERPA related to law enforcement requests, we really encourage schools to make sure that they're making contact with their own legal counsel to really review the details of the request and their next steps on a case-by-case basis to make sure that they're checking all the boxes and ensuring students all the protections that information is entitled to. We put in a note about school enrollment. Just like, again, I'm reiterating the point that Pietro made. We don't need and should not be collecting information beyond the proof of a Vermont and school district residence of the student and their family for school enrollment purposes. So this again goes to the limited information that schools need to collect that might overlap with information about a student's immigration status. We included a section here that I don't think has been touched on. This comes up in inquiries for parental assistance and school assistance in my office somewhat frequently. I think it's pretty common in other states in the United States to have some more informal process, also outside of a judicial process, for a parent to assign, many states call it power of attorney for education, to a different responsible adult. We see folks coming from other states with all kinds of paperwork that I believe is widely available online and that they're presenting as proof for any number of school questions, IEP team decisions, school enrollment. And that actually is not a pathway that's available in Vermont law. Our residency statute has many provisions for different ways that students can live with their parent, their guardian, state placed students, but we do not have the so-called power of attorney pathway to school enrollment and decision making. So we wanted to make sure that folks knew this here. We really wanted to forestall anyone relying on a process that actually we couldn't enforce here in Vermont because of our state law. We also point out that schools would do well to remind families to keep up-to-date emergency contacts in advance of any family emergency that might come up, including immigration action against the student's parent or guardian. So you can have, all of you know, you have kids in school or have had kids in school. You can have multiple safe individuals that are authorized to pick your child up from school. For example, you want to make sure that families have taken the opportunity to reflect on their needs and update that information. And then finally, in federal law, the McKinney-Vento Homeless Assistance Act creates protections for students who are unhoused or whose families lack regular housing. And there are many protections. There's some federal funding for this. We wanted to just put it in people's mind. We have lots of guidance outside of this document about the McKinney-Vento program, but we wanted folks to keep that in mind as things happen with students' parents. And then finally, we have this section that totally echoes what you've heard from the witnesses so far, that schools can deny access to any law enforcement official who does not have a judicial warrant. We've included here the prohibition on entering into agreements for immigration enforcement without the signature of the governor. So we just tried to cover all the ground as we knew it, got that out in January. We've sent it out in our weekly updates about just federal action generally several times to all superintendents.
So yeah, it seems like that last bit is most pertinent to what this bill is as well. Questions for Emily? I guess I just have a question as far as, so this does set forth what understanding of the law is as far as immigration enforcement at schools. And it does suggest that school districts, SUs and SDs should establish a plan for how and when they will consult with legal counsel in the event there's immigration authorities and such. So should there be further assistance or guidance on what kind of plan would be as far as, and would that be something that Agency of Education should be doing, or is that, and I'll be hearing from Sue in a minute, or is that something that Vermont School Board Association should be doing? And the other question is whether we need legislation to get that done, or if it's being done, or.
Right. So I'll again echo Pietro's comments that we have really strong training and uniform practice on these issues. We really benefit from that already. So I don't see, so I'll tell you a little bit about my job these days. I'm asking a lot of questions of risk management in the current federal context on behalf of the state and school district and schools. And so a guiding question, just for myself and my work, is would this change the substantive legal reality on the ground? I think in this case, right, the reason I asked myself that question is there is a risk of putting a target on Vermont in anything that we do. And we're constantly needing to balance how we perceive that risk for any issue against the need to allay fears, provide good, clear information so people can make informed decisions for themselves and their schools. So this is a case for me where I'm hearing that a state law would not change the substantive legal reality. Right now, we have a wide understanding of schools' Fourth Amendment protections and the Fourth Amendment protections for the people inside the schools. And we're very lucky that VISBIT and other organizations have been providing really high quality training for school officials to understand how to make that real in school. So no, because of what I've heard today, I don't see a need for a state law. I think the need for continued good, solid information and guidance remains. That should continue. As to whether that should come through a policy issued by AOE, I would say I think you're going to hear from Sue Sklowski that there is a VSBA policy on access that would speak to one of the requirements in the language that you've looked at as to entry to schools generally. Second, I think I would tell you about kind of our theory on legislating statewide policies, which is not binding on you. It's just kind of informing you how I see that education committees think about these questions. There are several topics where the General Assembly has required through statute a statewide model policy issued by AOE that must be adopted by all school districts. And the usual implementing language is that a school district must adopt a policy that is at least as stringent as the model policy published by AOE. That's usually how we get that done. That's a practice that I have observed the General Assembly use when an issue is of really high statewide importance. It's a value of ours that we want to see in every school, and where there's a good fit between the subject matter and one uniform policy, where it would make really practical sense for everyone to have the same policy to a level of detail that is not specified in the law itself, right? So it's filling in the gap between what the General Assembly is prepared to enact and what actually would need to happen on the ground, and saying that all of those details need to be the same in every school. I think that's kind of a poor fit for this subject matter for this reason. When we're talking about the ins and outs of things that happen at the physical plant of schools that are impacted by the number of buildings, the size of the campus, the location of doors, who staffs those entrance locations, we're going to find really, really, really diverse realities in every single one of our school buildings. And it challenges me as a person who might write this policy for AOE to think of more detail that is not stated in the law, but that could reasonably apply without creating massive problems to every single school district and each of every school district's schools. So, and I know I'm talking to an experienced school board member. So that's kind of the way that we think about the need for a uniform mandated statewide policy and the utility of such a policy. And I don't see those matching up for this subject matter just because of the very practical implications of physically accessing a school and controlling that access.
Is there a way to make sure that schools are in fact adopting plans as are suggested in that second from last paragraph in the memo? It does say, that they should establish a plan. But is there any follow-up to help them or to ensure that they are establishing a plan?
Yes, I think that the importance of this issue to all of our school boards and school administrators is driving activity out in front of any action that the legislature will then take. We heard really clearly from
Your
this.
voice went away for a second. I think if you move closer. Thank you.
Sure. So I think we've heard from Pietro Lynn that that's taking place, that all school districts are training on this need, are seeking information from their legal counsel appropriately as issues come up, and the practice in the field seems to actually be well out in front of a statute being enacted.
Karen.
Yes, thanks for being here. And I, going back a little bit, where you mentioned that you are evaluating the risk in these kind of decisions of like putting the idea out there versus the mandated policy. And I feel like one of the risks you shared is the potential for having a target on the back of all schools in Vermont, in this case, or certain schools. I'm wondering if you could outline what some of those specific risks or targets are that you think that schools would be, or Vermont in general, would be at risk for, just to help identify, to paint that picture of both sides of it.
Right. So I always remember that to answer that kind of question or think along those lines, we have to kind of put ourselves in the shoes of the federal government. And I think, first of all, that's something you can try, but they're unpredictable. Anyway, I won't make more opinions about the federal government at this time. I think we all understand. So one risk would be, I understand that allocation of immigration resources is in the discretion of ICE, and they decide how heavily to focus on one area of the country, one area versus another. I don't think we want to see any heightened ICE activity in Vermont. We also have faced several and expect to have to face more threats from the U.S. Department of Education and other funding agencies. USDA comes to mind for requiring that Vermont and all states take actions that they would direct according to their interpretation of federal law with our funding on the line, with our, all the funding streams for schools held in threat for noncompliance. We've been taking those on one by one and will continue to do so. I would not like to see us take actions that we don't think are necessary, that are going to increase that activity against Vermont's funding streams. We think that, we know that our actions are perfectly defensible, right? If it comes to having to defend the state's right and those students' right to that funding, we'll go to court and defend that. But we're trying to strike a balance between what is most needed and important.
If I can clarify, so those aren't any guarantee. It would be up to the current administration to decide to do that if they chose to. So that's where the target would come.
Yeah, absolutely.
Thank you.
Any questions for Emily? Not Cindy, thank you very much. Next time you make it to Vermont and you're in the State House, make sure you stop by to say hello.
Definitely. Thanks so much.
All right, we'll see you. Thank you. Sue, if you could join us.
Good morning.
Morning. So you're the cleanup guy.
Yeah.
You want to weigh in on this? Probably don't have to reiterate a lot of what we've heard. I guess just to ask you right off the bat is what kind of model, what kind of guidance are you currently providing to implement, along the lines of what I just heard from the Agency of Education and their memo, and what else can be done further with or without legislation, I guess is the question that we come down to from what I can tell.
Okay, thank you very much. I'm Sue Siglowski. I'm the Executive Director for the Vermont School Boards Association. And I would begin by saying that I really want to emphasize that at this time of increasing tension and uncertainty, Vermont school leaders remain very committed to maintaining learning environments where all students are safe and welcome and included. So I really want to start with that. And
Beyond that, I think the main point of me testifying today is to comment on the draft bill's requirement that the Agency of Education develop a model policy on the regulation of visitor access. And I will go into just a little bit of history. Act 29 of 2023 did require, you've heard about this a little bit earlier this morning, each supervisory union board, member district, or supervisory district board to adopt an access control and visitor management policy. And as a service to its members, the Vermont School Boards Association maintains a model policy manual. And that manual contains model policies for all policies that are required by law. And it also has policies that are recommended or should be considered based on state and federal law. So it's divided up into 3 sections: required, recommended, and to be considered. So shortly after the enactment of Act 29, the VSBA issued a model policy on access control and visitor management, which I provided a copy to the committee with my testimony this morning. So you have that. That very much tracks the requirements of the law at the time. Draft 1.1 of H511, as you know, requires the Agency of Education in coordination with the Attorney General's office to develop a model policy on regulation of visitor access to schools in the state. And based on past experience, we do have some concerns about that requirement. And I'll just briefly tell you why. The same Act, Act 29 of 2023, required the Agency of Education to issue, publicly post, and communicate to school districts and independent schools a model behavior threat assessment policy on or before December 15th, 2023. So that was the deadline, December 15th, 2023. 14 months after the deadline, the Agency of Education issued the long-awaited model policy on February 28th, 2025. Shortly after that, school boards started contacting the VSBA with concerns that the AOE's model policy was unworkable as written. And so given those concerns, the VSBA approached the Agency of Education and offered to assist in rewriting the model policy with content and format that school boards could adopt. And we're really grateful the agency heard our concerns and agreed to work with us on revising that model policy. And there's actually a meeting being held today. It's not the first one, but a meeting being held today working on that, that model policy. So we're currently in meetings with the AOE, the School Safety Center, and superintendents to redraft the behavioral threat assessment model policy. So we are concerned, given the agency's inability to issue that model policy in a timely manner, and the concerns that we had with the content of it when it was issued, that does lead us to be concerned with this bill's requirement that the agency develop and issue another related policy. I would say if the committee does move forward with this draft of H511 and doesn't remove that requirement, we would recommend that you provide the agency with at least a year to develop and issue the model policy based on these. It's actually based on experiences beyond the one that I just told you about, but also require the agency to collaborate with the VSBA in developing the model policy, and allow school boards 4 to 6 months to adopt a policy after the model policy is issued. And the reason for that is 16 VSA section 563 subsection 1 requires at least 10 days notice that boards have to give public notice of their intent to adopt a policy. And some school boards have policies on policy adoption, which require multiple readings of the proposed policy, which means they need to warn it more than once. So that's why I'm saying 4 to, if you wanted to go on the shorter end, I think 4 would be okay. But they would really, have to scramble and make sure that it happened within that time period. So those are really the comments that I came to provide this morning.
Okay.
Thanks, Sue.
And Tom first, I apologize. Tom, then Angela.
I just wanted to generically understand a behavioral threat assessment. What is the definition of that in your eyes?
That is a policy that is required by Act 29 of 2023. It requires schools to form behavioral threat assessment teams. And if you wanted to have more detailed testimony on that, we could certainly.
I guess what's a threat assessment to you?
So just real
Behavioral
quick, just really quickly on this,
Yeah.
because this is getting way off.
Right, all right.
I think the only reason that Sue brought that up was to explain that AOE is slow in getting us policies. It really
Yeah.
doesn't have anything to do with the
No.
online thing.
That's
So
Go ahead.
if we could hold that question for offline.
So what sort of timeline would we be looking at if the VSBA were to, could the VSBA take responsibility for sort of leading the charge in writing, coming up with a model policy, understanding there would be consultation with various other stakeholders? Is that something the VSBA would be able to do, and would it perhaps, could we do it on a shorter timeline?
I think the VSBA could do it on a shorter timeline. I would think that probably it would be very challenging to try to get one in place in schools by the opening of school for the fall. But I think that, we could probably do it within 6 months rather than a year.
Right, so then, what do we now, well, say it, yeah, so we could almost meet. Maybe it would be like the start of the calendar year, we could almost have policies in place, or you're saying that the policy wouldn't actually be written until about December? If it's potentially, is that 6 months from now to write the policy, right, not the process?
Well, I think it would be closer to October or November.
Okay.
Yeah.
So
But then school boards would need time to adopt.
Yes, yeah, so then there could be policies in place that the model policy could potentially be adopted by school districts sometime in the early part of 2026. If we're looking at that time.
Yes.
Tom,
Because it came up in context here twice, I would just like to know what a behavioral threat assessment is.
It may be, let me check because I could see if it may have been defined in the act.
It's of students.
Yes.
I didn't know what context it was, the student behavioral threat assessment?
So, yeah.
It's right to the school.
That's fairly self-explanatory to me. I was just trying to find out exactly where. Thank you.
You good? You good?
Yeah, I'm good.
Thanks. Anything else with Sue? Yes.
I guess I am wondering also, do you have a sense yet of, so now I see, and I should have known that the policy currently on the books for our district is the model policy offered by the VSBA.
Yes.
And it is very, it's not specific to understand, it's written in a different time and not
Yes.
specific to this, the circumstances we're talking about.
Right.
So do you have a sense of how many school districts in Vermont have policies in place right now? I mean, dealing with the specific circumstances we're talking about, either ICE or other law enforcement entry into school buildings, or do most districts just rely on this access control and visitor management policy?
I think every school district has the access control and visitor management policy because it's required by law. The only district that I'm aware of that has a more specific policy regarding immigration authorities is Winooski, but there may be others that I don't know about.
Okay. I just want to make that clear because I think we just heard from the AOE that there was this assumption that all school districts in Vermont have a policy addressing the circumstances we're talking about, and I don't think that's accurate. So I just as
Sounded
we
like they were
consider.
saying practice.
Yes.
They have a practice of how to deal with law enforcement.
Right.
differently.
Yes. Very different. And yes, very different.
Okay, I think we're, well, not so good, but to think about on this, but thank you very much.
Thank you.
For the testimony. So we're just gonna have Mike briefly tell us, remind us what H86 is, because we need to take a straw poll. We can do the straw poll after the floor, so people have a chance to kind of look and think again. But Mike, could you join us and I mean, do folks want a very quick explanation again of what you think H86 does? Are we all fine with that and just want to hear from Mike on whether there's been any changes since we've seen it? Just changes. Just changes? Just changes? Okay, yes. I guess people don't want to hear about small so much anymore. For whether there are changes.
Let me just get my notes and just give you a good representation of the changes.
And where would the latest version reside? Would it be in what meetings or would it be,
I don't,
or did you give us the latest version?
I don't think I did. There's a version on House Environment. It would be draft number 5.3. The 4/23 date.
4/23? Yeah. That may be the ones. No, okay.
So, changes from what passed out of Senate Judiciary or House Judiciary, what you proposed.
But we didn't pass anything on. We
Right.
made suggestions to the Environment Committee, whatever was in that version that our suggestions, which apparently they adopted.
Okay. So remember, you suggested that there be a purpose and intent section to lead off the bill and that was added. You suggested that there be language about a limitation on liability where it previously said the protection on liability. It said limitation on liability. You took away the deadline by which liability protection would begin because you have required the rules to be adopted by July of 2026. And then liability protection will start to attach once the agency sets up the program and does certification training. You didn't need a date for the liability protection initiation. And then in the municipal salt applicator liability protection, you require them to keep the same type of records as the commercial salt applicator. The House Environment Committee accepted all of those proposed changes. They have only made technical changes in the record keeping for both the commercial salt applicator and the municipal salt applicator. There was reference to record keeping for winter road maintenance, and because the use of salt or salt alternatives could be used for de-icing, winter maintenance, or dust control, winter was struck as a modifier and de-icing was replaced with salt alternatives, or sand. And then in the municipal salt applicator local roads curriculum, it was clarified that that local roads curriculum is voluntary, just as the commercial salt applicator certification is voluntary as well. Those were the changes from House Environment. House Ways and Means wants to clarify the fee report, and specifically that whatever fee that is going to be proposed, whether it's going to be charged by the state or by a third-party vendor, the General Assembly needs to approve that fee. Matt, those are the changes.
Okay. Any questions for Mike? So is appropriations passed it out yet, or
No.
are they taking it up today?
Today.
Okay, so let me get back on notice tomorrow.
Yeah, so, I wouldn't be surprised if it somehow doesn't find its way to the notice calendar until Friday.
Okay, all right, so we have, if we don't get to it this afternoon, we still have time to straw poll. And I mean, I'd like to take a straw poll probably on what our changes are that we put in there. I'm assuming that they probably also want us to have a straw poll on our view overall on the bill, since we have done a lot of work on it. Any view on that? I mean,
We could do both.
yeah, like we've done before. Okay. All right, thank you for
You're welcome.
being able to be available. So we, if you could print off that latest, yep, and let us all have that, and then, hopefully this afternoon we can get to that. Straw poll, and then discussion, straw poll, there's 2 straw polls. And we're also looking at H-193, H is that study working group that Defender General really didn't like very much at all, and others did, for representation in Chin's cases, supporting representation in Chin's cases, and we do have a new draft that may or may not get us there, but we're going to take a look at that and have testimony on that this afternoon. And if we all agree and think it looks good and worthy of being in the miscellaneous bill, then we'll put it in there. Otherwise, we'll just continue to work on it separately and probably won't happen until next year. All right, so we're adjourned until just after the floor, which shouldn't be horribly long from what I understand.